Deputy District Attorney Anne-Marie Rosa with a lesson on hearsay evidence and how it is treated in court. Most people have heard someone say, "That's hearsay." It is a term that gets thrown around casually on movies and TV as a way to claim a statement is unreliable. The legal definition is two parts. First, it's a statement that was made outside of the courtroom in the current proceedings. Second, it is being offered to the judge or jury in order to show that the content of the statement is true. So, the rule to remember is that hearsay is an out-of-court statement being offered for the truth of the matter asserted. Before we get into all the nuts and bolts, let's talk about why we have these rules. Hearsay is something the law has deemed unreliable. If my friend tells me her boyfriend torched his car to collect the insurance money, I don't really have first-hand knowledge of whether that's true or not. So, if I'm on the witness stand testifying about the story she told me, it definitely makes the jury listen, but it doesn't actually mean it's true. This situation could get dangerous because it's so easy to spread misinformation, #fake news. For this reason, hearsay is something courts do not want to allow in. As such, the general rule is that hearsay is inadmissible in a legal proceeding. With that said, there are a lot of hearsay exceptions. Those are situations in which the law has made room for because there are moments when regular hearsay might actually be reliable, situations when we should let an otherwise unreliable statement come into court. Here are some of the exceptions contained in the California Evidence Code. Co-conspirator's statement. Statements made during and in furtherance of a conspiracy. Declaration against interest, statements against the speaker's financial, social, or penal interest when the person is unavailable to testify. Former testimony, testimony given under oath in a previous legal proceeding or deposition when the witness cannot attend. Prior inconsistent statement, earlier statements by a testifying witness that differ from current testimony. Prior consistent statement, earlier statements used to rebuild credibility after a witness is accused of lying or bias. Past recollection, recorded, written records of events a witness once knew about but can no longer remember clearly. Think police report. Prior identification, an eyewitness identification made soon after perceiving the event while the memory was fresh. Spontaneous, contemporaneous, and dying declarations. Statements made under the stress of excitement caused by a startling event. For dying declaration, the person must in fact die. If not, then they are available to testify. Contemporaneous statement, statements explaining the speaker's own conduct while doing it. Remember, the first rule we need to look at is the part about there being an out-of-court statement, which is usually pretty easy to identify. Out of court literally means the statement was said or written down in some place other than the courtroom in the case. Let's look at what qualifies as a statement. It could be something spoken or written down. It could even be a gesture that does not involve any words at all, but is still nonetheless an action that is used to convey meaning. For example, if I nod my head up and down, that means yes. What about truth of the matter asserted? When we say offered, it means offered as evidence in the case. The truth of the matter asserted is about whether that statement being offered is going to show that the thing said is actually true and not false. Put another way, are we giving this statement to the court because we want to use it to show what we are saying in this statement is true? Deputy District Attorney Anne-Marie Rosa, and that was our short lesson on hearsay evidence and how it is treated in court.